Legal framework is relevant to business transactions. There's a wide range of private and public laws, including contract law, secure transactions, property rights, and government regulations. They all affect business transactions. Now, we cannot review all of them in 4 days lecture, obviously, but we need to deal with the most essential part of it. In my view, that is property and contracts. And we will also deal with a part of secure transactions issues. Okay? So let's begin with contract. The contract is commonly understood legally binding business commitments. Just give me 1 second. It's important because business transactions would not be feasible without some sort of stability in business transactions, and that stability comes from the binding effect of legal commitments. So the promises that are made in business transactions would have to be binding, otherwise the promises will not be stable. Without stable business commitments, obviously the business transaction will become very difficult. What do you mean by creating business commitments legally binding? That means you will create a price for not performing the promised transactions. So people will have a sense of commitment, understanding that the breach of which will incur a price for them. So that's the basis of contract. Creating promise, which translated into business commitment, breach of which will result a price. Now, contract law also clarifies the terms of transaction. So first of all, it created, as mentioned, business commitment that's feasible in transactions. And second, the contract law and contracts tend to clarify the terms of transaction. Now, when we're discussing contract in an everyday sense, it does not mean a piece of formal document. That's what many understand as contract. Contract has a form, but these are two different things. In most jurisdictions, contract does not require a form, as we discuss later, unless it's specifically necessary and stipulated by law. So the form and contract are two different things. And contract is in fact found in day-to-day business transactions. So a popular example is, now somebody comes on the street and hail for taxi. Right? Taxi comes in and takes in customer. No verbal promise has been made. The act of transaction there is obviously somebody comes on the street, hail for taxi, taxi comes in, you ride in, and probably the only word that's been spoken is destination. And taxi takes that person to that destination. Now, what is this transaction? Well, nothing has really been spoken other than probably the destination, but still this is a contract. How can contract be made without verbal, discourse? Contract could also be made implied act. So when you're hailing for taxi, the customer recognition of that act in most cities is that you will accept the taxi that's coming on and you will get a ride, and when the taxi gets you to destination, you will pay for it. That's all implied in conduct. So in fact, contract, as shown in the example, happens every day whether or not there is a documentary execution. So one sense that we can understand that contract does exist everywhere. And contract law is something that affirms that transaction, which exists everywhere by law. Okay? So now you understand why we are dealing with contract in such an important connotation, because it happens everywhere. And contract law has a function of making this everyday activity into something that could help economic development. So that's the process we're going to look at. Why contract law matters and what is contract. And because of that, we need to understand the most essential elements of contract. We're going to spend some time on it. Now, if you do have a background in common law contract law, that this could be a bit of repetition, but for those of you who have not, I think it's important to understand the essential terms of contract and contract law so that we understand what we're dealing with. And later on in the lecture, I'll try to cover what is a strategic adoption and implementation of contract law. What part of contract law should be adopted and what part should be implemented with importance to facilitate economic development. All right. So as a starter point, it's a mistake to believe that business transactions based on contract that only exist in certain places. Even some lawyers believe that that's not true. The business transactions that form the contractual basis does exist every day, and it happens on everyday life. Now, one way to understand this contract is through certain classifications. So, many jurisdictions tend to categorize contracts in certain ways, and I note these three categories especially helpful. One is to distinguish contracts based on relational contract, something that's called social contract, which means that relationship among the family members, relationship among friends, and certain promises are made that has a business implication. So let's say that a father makes a contract promise with a son to give him a certain a good, say, if you do this work, then I will give you a car. The promise made by family members, many jurisdictions, they do not deal with such relations in normal contract law because we call that as something signifies relations. So it's called relational contract. And the way that's dealt with in many jurisdictions is with social sanctions. So instead of bringing it into court, many jurisdictions would not recognize them as commercial contracts or private contract. We'll get to it in a minute. And those contracts will not dealt with in the courts. Again, the contracts that are made based upon relations in the family and some cases in friends, and they do not be dealt with in a normal contractual fashion. Private contracts are the most of contracts that we're dealing with in business transactions. Commercial contracts, the contracts that have economic connotations. So person A, not a family, not a friend. Person A deals with person B on the street to sell a car, for instance. That we call a private contract that is made among private individuals and companies, and that attracts civil sanction for breach. So you do bring those cases to the court for civil sanctions, monetary damages, and other kinds. Third category is called public contracts. Public contracts. Now, these are a part of commercial contracts. The contracts that are made between individual and large corporations or a group of corporate body that has a significant business and economic influences in society. So let's say that I'm making contract with, say, Samsung to buy a cell phone, for instance. Samsung is obviously a mega company across many countries, and they do business on a scale that any individual can really not be able to match. Now, these are strictly speaking part of commercial contracts that we see every day, but because of the disparity between the influenced party in transactions, individual versus big companies, we call them public contracts. Those public contracts come with standardized terms and prices. So when you're buying a car from a big car company, or when you're buying the cell phone from a big electronics company, refrigerator, you do not negotiate the terms. You accept the terms, you sign it. But that's reality. Because of that disparity, we call them into a special category of contracts, public contract, that not only attract civil sanctions, so you can bring those cases to the courts, but also the governments take interest because, again, the relationship is not in parity. So these contracts tend to attract regulatory sanctions, sanctions made by government. Okay, through what? You have a special statutes to govern that. So home finances, that when an individual takes a financing product from a bank over a purchase of a certain product, then it's subject to statutory control. Okay, so this is again on public policy and has a significant relevance to economic development concerns. We'll get to them later too. Now, in contractual relationship, which is a basis of economic development and modern economy as a whole, there is implicit call for reciprocity, which means that the parties to the contract will give and take. So in, again, most jurisdictions, there is no contract unless there is a performance exchanged. So if I make a promise to give a donation to University A, say in 10 years' time, I will make gift X to university. That is obviously a promise that has economic implications, especially for the university that's going to receive that gift. But in Anglo-American jurisdiction and others, it's called gift. It's a promise that may well be accepted by the university, but there is no reciprocity. I give the gift. University gets it, but I do not get anything from university in kind. Of course, there is a gratitude, but we don't, call that as a contractual performance. So in order for contract to exist, there has to be an exchange of performance, reciprocity. So when the reciprocity does exist, and business transactions are formed on the basis of the contracts, the rights and obligations in the transactions would have to be respected and observed. So rights will have to be protected, obligations will have to be enforced, and this mechanism, protecting rights in business transactions, enforcing obligations in business transactions, would form essential ingredient for economic growth. So I think I have made it very clear as to why we need to understand contract and contract law for economic development. Then today I thought I would deal with a few very essential elements of contract, which includes, again, formation, validity, rights and obligations, and forms, which tend to cause confusion, and defense. Private property rights, again, are a prerequisite to valid contract transactions. I've heard from a consultant who tried to give advice to a former communist country. So back in the 90s, a consultant was trying to help North Korea when the relations with America was better then. They went into North Korea and tried to set up a contractual device, the statutes that would protect certain types of contract, investment contract in North Korea. The problem, he mentioned then, was because North Korea did not recognize many of private property rights, so there are very few range of properties where you could be recognized ownership rights. He found it very difficult to set up a contract protection statutes where property rights are very limited, which again means that in order to have a valid contract, in order to have a good contract law, the basis is that you do have a recognized private property rights. So they go hand in hand. So if I were you, I would go back to the previous lecture when you have time and see how they correlate with contract. It goes hand in hand. You do have a private property rights, and you do have a basis for good contract law, good contract mechanism to enhance economic growth. It's difficult have one without the other. As we saw yesterday, private property regime will not be promoting economic development and good economy without good contractual markets, such as labor market. We talked about capital market. All those markets will have to have a good contractual basis, some of which we'll discuss today. Without that, then property, the rights reform had very limited effect. And vice versa, without good property rights base, whether it's recognized by registry or by convention, it doesn't really matter, but you have to have a recognized rights system in the economy to have a good contractual mechanism. So it is prerequisite that private property rights must exist in good standing to valid contract transactions among private individuals. So it is conventional wisdom, again, that contract is cornerstone for the market economy, and no market transactions could exist without valid contracts. So primary function of contract law is to recognize, protect, and enforce contractual rights. We have to deal with enforcement. Again, if you recall from the last lecture, it was important to have a good system of rights, meaning that you have a system of law that recognizes rights, but it was probably more important to have a good compliance and enforcement system, which required state capacity and institutional framework at the same time. Same here in our discussion of contract. The function of contract law, because it's recognized, protect, and enforce contractual rights, you have to have a good enforcement in a case of breach. And that goes to, again, the issues of institutional effectiveness and state capacity. So now I think we're in the middle of our program, but you would have a perspective that in any law reform project which advocates certain, the legal reformation, then first thing you will look at is whether the institutions and state capacity that's required to enforce that part of law is there or not. If not, then you have a prerequisite consideration that has to be reviewed by the state and yourself. After we are done reviewing contract law and enforcement issues, then I would like to spend a moment to go over secure transactions. Again, some of you already know what this is. Secure transactions create a legal interest in property to secure credit. What it does is to enhance economic credit market, especially for small business holders and players. So that is believed to be promoting economic development. So State Department is promoting this, the secure transactions, quite heavily in the context of promoting economic development. Some institutions such as University of Arizona is very interested. I was once asked to consult on this. But we do have limits in secure transactions contribution to economic development. We'll go over that. There are cons and pros of building up secure transactions system in developing countries. In all of this, especially in secure transactions consideration, we have to look at the use of customary property rights, because in reality, again, back into last lecture, even if you have a largely successful reform, the reality will be for a substantial period of time, you will have both reformed formal land registry and property registry and informal system going at the same time. That's the situation in Cambodia, China, Thailand, and elsewhere. Okay? Right. So, contract validity. If you have studied contract law, then you might have seen the formation first and go from there. But I like to take a look at the validity issue first because it has a much relevance to economic development. So let's take a look at that first. What do you mean by contract validity? It is a question of subject matter for contract, and it is a question of what can be contracted among private individuals and what cannot be. So contract law is understood as a private law, which means that the law that governs private relationships. Person A, person B, who has property right, make transactions. And contract law governs the relationship. That's our understanding. However, the part of contract law also worked to determine what can be the subject for contract, what cannot be. There are a couple of approaches to this. There is a liberal approach and there is a restrictive approach. Liberal approach means that unless the law says otherwise, you can contract anything and everything. You can sell and buy, say, a car. You can buy a house. You could hire somebody to teach you law. You can hire somebody to teach you music. So anything at all that can be contracted. Most of capitalist societies would uphold this. Restrictive approach is that there is restrictions on the subject matters that you can have a contract for. So a good example would be the socialist economy, where, again, this is related to property rights issue, because in socialist economy, your property rights were not recognized. So you might have a actual possession and control of movable items, but you cannot have a right to your house, you cannot have a right to your factory, you cannot have a right to your land. So obviously, these items where you cannot own could not be subject to contract. Because it's so restrictive, because in, for example, socialist economy, there's so little you can own legally, the contract law itself has a very small place or none at all, because you cannot really contract many things at all in your life. You just can't have contract because you don't own those things, right? So in most of capitalist society, matter of fact, all of them I know of, it has to be a liberal approach, that you can contract anything unless it's prohibited by law. In restrictive approach, you cannot, in principle, contract anything unless it's permitted by society. So now you can understand the dilemma. Then when consultant went into North Korea, where the system is still largely socialistic, so you cannot own property unless it's particularly approved by the state. And then state wanted to have a law that authorizes, that liberalizes certain investment activity. So because that ownership relationship wasn't clear, it wasn't clear in the law what an individual can or cannot own. Now you can appreciate the difficulty in which, how you would organize that, in a way, special contract law, because the prerequisite to contract law, that is property right, wasn't very clear in North Korea. It's not only North Korea. If you look at other economies in transition, developing countries in transition, such as China, Cambodia and others. Now China has become effectively a capitalist country by and large, economically at least, after 2000. But many other countries, that relationship isn't very clear, and that has become impediment to adopting Western-style contract system or contract law because of the existing restrictions on the ownership issue. Okay? Another area, if you're in consultation business, another interesting area is the clash between contractual regime and property regime. So on the one hand, the state wants to promote contract, especially to attract investment. And then you don't have a clear property rights system organized within the state in an extent that you have made a contract, valid contract, you thought, to do something in that country, and obviously the property rights that have to be associated with it were not fully recognized or realized later on. So Agency B, which governs a registry of property, says something else when you do have a valid contract you thought, right? So again, the point I want to make here is that the relationship between the property rights and the contract should be very clear. One way to resolve this is a licensing. So let's say that, again, back in North Korea in the 90s, that they want to bring in investments by recognizing property rights to their investments. Again, the problem is that in the whole economy, the general property rights to that subject of investments were not recognized. And how do you do this? How do you create the rights to property which are subject to contract? And one method, one technique you can use is a licensing, that North Korea made it very clear in their law and in contract that investment property are licensed so that the rights to property and rights to contract are fully protected. So you can grant contractual capacity by licensing, even if general contractual rights or property rights may not be very clear. The notable area where licensing was prevalently used was export and import licensing. In the period of economic development, in many so-called market economies, such as South Korea, to some extent Taiwan, and others, the government had an issues about import and export. The reason was that they wanted to promote economic development, and as a way, they wanted to promote domestic industries. And they were concerned that imported products and services could be in competition with domestic products in a sense that this competition might undermine your growing domestic industries. So they wanted to limit the contractual validity in this area, meaning that they will not allow, in generally, export and import contracts unless it is licensed. Now, this is slightly different. It's not so much that economies will not recognize general contract right or general property right. They did. But in this case, for a strategic reason, for economic development, they would limit the right to contract in certain areas. It's not just export and import. There are other areas I'm going to go over. But here, export and import were considered a strategic area where it has to be coordinated in accordance with the development of domestic industries. So the policy decision was to limit contractual capacity in export and import, particularly import. Another smaller reason for this, other than strategy, is a potential revenue for government. So in East Asia, you saw that this licensing was practiced for strategic reasons, but in many other developing countries where taxation is very weak, again, the state capacities for taxation were limited, then they used import and export as a ways of raising revenue by levying tariffs. It's relatively easy because all you have to do is control the borders and tax imports and exports. So that was a revenue reason for the government. So one way or another, the export and import has become a popular area for limiting contractual capacity. Another interesting area where contractual capacity or validity is limited is a land transactions. Now, when there is a rapid economic development, then usually you will see the land price rising very rapidly. So I'll give you an example. When Korean government, when Korean economy was developing at close to 10% per annum, which is very high, for almost 30 years, and especially in the 70s and 80s, it was a high-growing growth economy. And then the demands for space in industrial areas, such as industrial/economic areas, such as big cities, the land price and land demand were going up very high. So you will see that the price of residential houses going up at, say, more than 10% a year. Not just in South Korea, in other vibrant developing economies such as Beijing, Hanoi, and other places, you see the prices of land and houses go up very fast. The problem with that is then the residents in those areas, wage workers, small business, they suffer from this rising price because many of those people will be tenants. They do not own the house, but they are tenants. So the problem is that when the prices of those land goes up quickly, then the landowners will have incentive to raise the rents, or they would want to sell it because the prices are very high. So that puts a lot of pressure, economic and social pressure, on a majority of population in those areas, causing all the social issues and economic issues. So one way to control that, I mean, again, this is a market economy, and you can't really put a cap on rent, right? So one way to control this indirectly is to limit land transactions in those areas. So back in 70s and 80s, South Korea would impose a very high rate tax, over 40% for any profit raised by land transactions. Now that didn't stop because you get, the rest, 60% is a profit anyway. So later on in the 90s, the Korean government would limit land transactions by requiring license. So in order to make land transactions in certain key areas, the places where the land prices are going too high, then government would impose a licensing requirement so that you have to make a case as to why is it economically necessary for you to do land transactions. So, for instance, you have to make a case for, say, you want to set up factories. You're going to employ a lot of people. You need land. Or, your parents died and their house is no longer necessary, and I'm selling them off to somebody else, or can we move to someplace else? You have to make a case for that. So that's another interesting area where licensing was used for transactions. And another more popular validity issue is based upon personal capacity. Now, again, if you've studied contract law in Anglo-American jurisdiction, then you know that a minor person is not fully obligated under the contract that he or she may have signed. We call that capacity issue. The reason is obviously to protect a minority. The problem in developing context is in many developing countries, because of the issues associated with family structure and the socioeconomic conditions, many households are led by minors. It's not uncommon. And those minor people will have to go to work to feed their family. So in the process of doing that, the minors will make a lot of transactions based upon, again, mutual promises. So there is an economic reason to recognize this contract, even if the contract was made by a minor person, because it's necessary to enable minorities to engage in economic activities. If contract law tries to protect the minority by giving minority an option to cancel a contract, then there would be reluctance in the society to engage minors because you never know whether the contract that's signed by minor will be enforced. So in this case, the traditional limitation on contract validity based upon a minority protection would have to be waived or reduced in the context of economic development. There are other validity issues based on public policy. So illegality of subject matter. Again, a contract to sell and buy a drug, perhaps. Drug is obviously a controlled substance. It's illegal in all the countries I know of. So obviously a contract to do those things will not be enforced by courts. And there is a prohibition against usury. Usury is a loan transaction that requires a rate of interest considered by many societies as excessive. So, different country has different rules about it. Some countries would say that it's a usury if the interest rate is over, say, 200% or even less. So in this case, a contract validity based upon those loans can be controlled by the state for public policy reason. You want to protect poor people in society by making sure that they are not harmed by excessive interest rates. How is that related to economic development? Economies that are developing very fast, obviously the money is valued commodity. There are many areas where investments are necessary and demanded. So obviously the price of money. What's the price of money? It's interest rate. So interest rate in highly developing economy tends to be high. So then you have the social concern that strict prohibition against usury might shrink this market. So there has to be a balance. On the one hand, you still want to protect the poor people. On the other hand, you don't want to do it excessively so that high growth economy is not hampered by shrinking private loans market, much of which may include usury elements in it. So all this shows that a contract law, by controlling validity, there are two ways of doing it. One is that fewer number of states would actually stipulate the cause for controlling validity in general contract law itself. In Anglo-American jurisdiction, it's probably unheard of because we do not have something called contract statute. The contract law is a common law. It's a law set by courts, so we do not have a comprehensive law on contract. But many others there are, and one possible way to control validity, either for public reasons or economic development reasons, is to put that controlling elements in the statute, providing the grounds for controlling the validity. But in many more countries, in more jurisdictions, a more popular way is to set up a special statute that allows the state to control contract validity by putting up licensing requirement. So back in the land transaction cases, then Korea would enact special land transaction statute to enable state to license land transactions. One thing that I've omitted here is that the validity of contract in many countries are restricted for dealing with minerals, the valuable minerals such as oil and gas. Now, some states in the United States, whoever was finding it in a common land, public land, would purchase own portion of that oil and gas. But in many other countries, it's owned by state, and the individual who finds it will get a small fraction of interest, either by lump sum or by continuing interest, but it's limited. So in that case, a private transaction attempt on those controlled minerals will be limited. You're not going to have a full liberty in contracting those subjects, and in that case, again, controlled by the statute that stipulates grounds in which that validity of contract on those subjects could be controlled. Now, the validity issue was there, and the formation. We need to take a look a little bit about formation to see how contracts are made. Again, if you have studied Anglo-American contract law, this is a bit of repetition, but bear with me. Most jurisdictions, in order to make contract, there has to be a prior exchange called offer and acceptance. Offer means that what you wish to do in business transaction, that wish has to be accepted by the other party in a form of mutual promise. Offer must be clear and definite. So anything that you're saying which is not clear enough, which is not definite enough, I wish you could do something, that's not an offer. Acceptance would have to accept the offer as is, in most jurisdictions again, and acceptance cannot change the terms of an offer. So that's the key of formation. There has to be a clear and definite business proposal, so to speak, which has to be accepted in clarity and absolutely. However, in real life, that doesn't, acceptance, for instance, can be not definite. The offer can be not clear enough. So in everyday life, it's not uncommon to see a proposal unclear, such as, look, I want to sell this, my car at a market price. I'll look it up. Is that an offer? In a common law sense, no, because you don't give all the terms in a clarity. Or in acceptance, you can say, okay, I'll be happy to take your car, but I want you to clean it before it. Again, in strictest interpretation of common law, acceptance has not been made because you have demanded cleaning of the car. But in reality, that's a trivial addition to it. So in everyday life, especially in developing economies where legal sophistication is not yet there, information, liberal approach is helpful, meaning that if the term offer is not very clear, even if offer does not have everything, nonetheless, if the offer has the most essential terms that are ascertainable, which means that we can figure out what the market price is. And if you can go to certain guides, obviously you're going to find it. Even acceptance, even if it is not exactly accepting the terms of the offer, if a reasonable person will find the transaction, enforceable transaction out of it, then it'll be a good idea to recognize the contract as is. Matter of fact, this approach, liberal approach, which does not require all the terms in the offer and all the clarity and in acceptance, are taken up by some legislation, such as the UCC, Uniform Commercial Approach. Uniform Commercial Code. UCC is a uniform commercial code in the U.S. Some of the fun that the contract teachers enjoy in teaching contract law is a battle of the forms. I think you'll find it on your slide, the panel. You'll take a look at that. The point of that is, if an offer does not match acceptance, or if acceptance does not match offer exactly, do you not recognize a contract? In realistic point is, even if offer and acceptance deviate from strictest interpretation, it'll be a better approach to recognize a contract with the terms, as long as the terms can be confirmed later in time with reasonableness. So, if an offer doesn't say anything about price, maybe it's difficult. But if offer stipulates a price that is to be determined by, say, a certain price index XYZ, then that might be okay. Acceptance too. If the acceptance does not mirror the terms of offer exactly, but nonetheless, if acceptance can be verified by conduct or by the reasonable judgment in society, then again, preferred approach is to recognize contract on those bases. So no literal interpretation, but more broad and liberal, not literal, but liberal approach to recognize contract more easily. A small thing, again, being asked by the lawyers trained in Anglo-American jurisdictions, consideration. Consideration is a requirement of common law that the promises will have a mutual price. So if I promise you to do something, then you must give me some benefit out of it. So there has to be a mutual benefit for a contract to be recognized. Well, in actual commercial cases, this is rarely an issue because most commercial contracts would require exchange of benefit, right? So I don't think that is much of an issue in practice, and it has a limited implications for commercial transactions. One other thing that I would add is, in consideration of contract in the context of economic development, one has to recall that there is an international device called the United Nations Convention on Contracts for the International Sale of Goods, commonly called CISG. Now, CISG governs contract formation and rights and obligations of the parties for the sale of goods. So it does not apply to services. It applies for the sale of goods between parties. Now, the number of countries that are signed up for this convention is 83. So what it does is this is international law that governs contract formation and rights and obligations. The reason for doing this is for international transaction, it'll be much better that parties do not have to worry about different formation issue, different rights and obligations issue. So it's common. It provides a common rules for 83 contracts with respect to international sale of goods. But the good thing about this, the flexibility, I like it, is that application of CISG can be determined by the parties, which means the parties in those countries can stipulate their contract that their contract is not governed by CISG. So this is a choice rule, okay? All right, let's turn to form and defense and discharge here. Many are confused that the contract requires a form. For practical reasons, that's the case, but contract itself doesn't. Form is a requirement of signed writing, and certain kinds of contracts, the formality tends to be required. For the importance of subject, that tends to be the case. So the contract that transfers in the interest of land, contracts that cannot be performed within a year, collateral promises, for the sale of goods over a certain value. In some jurisdictions, these are the examples of contract that requires a form. And a contract normally provides for defense. So some of the conducts are basis to defeat a otherwise valid contract, which includes mistake, misrepresentation, duress, and undue influence. Let me explain just briefly here. Mistake is a mistake about the subject of contract. So one was considering making a transaction over, say, Mercedes-Benz. The other was thinking it was a much cheaper car. Now, if the mistake was made by both, then that tends to be a defense. But unilateral mistake, let's say that the contract states in a form that a Mercedes-Benz has been sold to to me, and I thought that Mercedes-Benz is the same as BMW or some other car. That's a unilateral mistake made by myself without the fault of the other. So unilateral mistake does not normally provide a defense to contract. Misrepresentation is untruthful statements, either by intention or by mistake, of the subject, and misrepresentation. So I was explaining to you that product A is the same as product B, which is not the case, and that is a basis of defense. Duress and undue influence is also a cause for defense, and duress a compulsion, so I'm either physically or otherwise forced to sign a contract, and that is normally a defense. And undue influence is those require relationships. So somebody who has to take care of the other. In legal terms, we call it a fiduciary relationship. So a guardian, for instance, whose responsibility is to take care of a minor, makes a contract with a minor to benefit the guardian, him or herself. Then in this case, because of these relational issues, that the transaction is considered undue influence and it is a defense. Now, contract performance has to be in compliance with the terms of the contract, and we call that the substantial performance. So in order for performance to be valid, the performance has to meet all the terms that are essential to achieve the objective of contract. So the normal question is whether a breach is there. Is that a basis to cancel the performance? And the answer normally is whether it meets the standard of substantial performance. So let's say that a house is to be built by contract. And say there is a stipulation that contract, the house should be painted in gray. Brown. So instead of brown, you saw all the houses, walls are painted in red. Would that be a breach of contract? It would be, because it would be a violation of stipulation. But is that a basis to cancel performance? Probably not, because all the essential terms of the house is to make something that can function as a house. So painting a house in the wrong color may not be good enough to cancel a contract. What about building a house without roof, without windows? That might qualify, because the house without windows or walls and obviously will not carry the essential function of the house, which is to house people in the unit safely and functionally. What about the minor damages then? Painting the house in the wrong color. It may not be good enough to cancel performance, but it is good enough to damages. So essential requirement of performance in a contract is that the contract performs substantially to meet all the essential terms of the contract that are important to meet the function, the purpose of the contract. All the other failures are considered minor breach, and that may attract damages. So legal standard for assessment is reasonable compliance. So when you are evaluating performance, what's the standard? It has to be reasonable. Reasonable means that a person of reasonable judgment would have done and recognized. So it's essentially local standard. So you are going to a doctor for a treatment, obviously. Then it's a contract because you're giving money to the doctor for treatment, and doctor give you treatment for money. So that's a mutual promise. It's a contract. So how good the treatment has to be then in order to meet the performance requirement, how good the treatment has to be. Now, the standard of treatment in, say, Kansas City may well be different from the standard of treatment in somewhere else. So the requirement of the treatment will very well be a local standard. Another important principle of contract is privity. The privity of contract means that, in principle, only the parties to the contract are entitled to the benefits and obligations. So who can sue the contract? The parties. Exception is, in certain cases, third parties may benefit from the contract. So I make a contract with a person B so that the person B will give certain goods to my son. And obviously that's contract between me and the other person, but beneficiary is my son. Can my son sue on this contract? Depends. If the purpose of the contract is to give that product to my son, stipulated in the contract, then my son is called intended beneficiary, he can sue. But let's say that I have...
Hi, Steve. Steve, I'm sorry. This is Ashish. I'm sorry to interrupt.
Okay.
I just had to step away, but I just wanted to let you know I am here.
Okay, good. Well, good to hear from you. All right. Okay, let me continue on here. So that will be intended beneficiary and he can sue. Now, incidental beneficiary is something different. That I have a contract with, say, you, so that you will give me a quantity of, say, flowers to the hotel I'm running. With the knowledge that I have a guest, very important guest coming in to my hotel. Now that has not been communicated to you, but the fact is that I am bringing a very important guest who would appreciate those flowers. Now, the purpose of the contract does not state that I will please that guest. In this case, the core of the contract is that I'm getting flowers from you, and these guests who would enjoy these flowers are incidental beneficiaries. They were not stated in the purpose of the contract, but they would nevertheless enjoy the product of the contract, which is delivery of flowers. In this case, it's a little bit different from the other case, isn't it? So in this case, the guests are called incidental beneficiaries. They cannot sue. So these are the basics of the contracts. Now, the contract presumes equal or equitable bargaining power between the parties. But as we have mentioned in public contract case, the reality is that it's not always the case. The parties do not possess equal bargaining power, to the point that sometimes there is no bargain at all. And it happens every day, both in developing and developed countries. When you're trying to buy a cell phone from somebody, you will hardly be able to negotiate at all. When I'm trying to buy a car from a car company, I'm not negotiating contract, I'm signing the form. So there is an issue of economic efficiency and social justice. If the contract law requires negotiation between me and any other party over any other transaction, then I will probably have to a lot more for the goods I'm buying. If Samsung will have to negotiate a terms of contract whenever they sell me a cell phone, if a General Motors would have to negotiate by law a contract with me every time they have to sell a car to me, then obviously the price I will have to pay for cell phones and cars will be a lot more. Presumption for classical contract law do not seem to exist, and there are substantial inefficiencies associated with making that to be equal. So on the one hand, if you're trying to create equal relationship in a contract law, which would be ideal in classical setting, then there is economic issues. But if you would allow those big players to use their superior positions and give whatever terms of contract they want without any restrictions whatsoever, then there can be a substantial social injustice, and plus there might be implications for economic development. So there is a critical balancing issue, and some of that I'm going to take a look, okay? Let me see if I could share my slides. Okay. All right. All right, so let's move on to a remedy issue, because again, this is also relevant to developing economy. The remedy for contract breach in most of jurisdiction is money. It's money damages. Why? Because contracts in economic context are economic transaction. So the reason you're going into contract in economic context is to make money. That's a presumption. So if there is a breach for the contract, then the remedy that the state will provide is a money that you would have made. Okay? We call that expectation damages. I'll give you an example, a simple example. Say I'm supposed to buy a car from you under contract. Say I'm paying you $20,000 for it. And I know that in the market I could bring the car to the market that I want, and I could sell it for, say, $25,000. The breach occurs, then I'm not getting a car from you. Then what happens is the court does not give anybody $20,000, which is a car price. What court will do is to see how much money I would have made had contract been through. And the court will find out the profit I'm going to make here is $5,000. So that's what they will order. They will order my expectation out of this contract, which is $5,000. Okay, that seems to, again, practice of the majority of jurisdictions. So we call that the compensate for lost bargain. Court may, in some circumstances, will give consequential damages. That's damages for foreseeable consequential loss. So here's another example. I have a contract to buy, say, 30 pounds of flour from you. And you know that I'm running a bakery. So I need that flour to make bread for my customers that are coming in tomorrow. And for some reason, you're breaching. Not only I have an issue with not getting those delivery of flowers, but I have a consequential issue of not being able to make those breads for my customers. So not only you're responsible for the delivery, non-delivery of flowers, you'll have to cover my losses out of those missing bread sale to my customers. That's consequential damage, something that you could have foreseen. You should have reasonably foresaw. Again, this creates a complication. This could be an argument. Look, I didn't know that you were running a bakery. I didn't know that you were getting so many customers, so forth. So in many commercial contracts, those damages are liquidation damages, meaning that damages are stipulated in the contract. So in the event of breach, a certain amount will be paid, right? And again, many jurisdictions, those liquidation damages are recognized. A few more things about the contract. Contract may be canceled for a material breach. Now, two things, sometimes even young lawyers get confused. Damages are always a remedy available whether or not contract itself is canceled. There are different kinds of breach. You can always go for damages, monetary damage, whether or not the contract is in progress. But in certain serious breaches, then contract itself can be canceled. That's another remedy. Breach is so serious that you don't see any point of going on with the contract. That can happen. It happens for a material breach. The breach that is so serious and the purpose of contract as a whole cannot be met. So, good example of this is building a house, and you have a well-functioning house painted in a wrong color. That's a breach, but it's not going to be a material breach because having a wrong color will not frustrate the function of house. People can still live in there. But let's say the house without roof, house without windows. That might be a problem and will constitute a material breach because no one can live in a house unless you're living in a tropical area, house without a roof or a window. For a material breach, the remedy is cancellation. Another interesting type of remedy for contract is a specific performance of injunction. I've mentioned that in principle, the contract remedy is money. and that's correct. But sometimes money won't solve the issue. Say I am supposed to get a delivery of very special product, special machinery, which I cannot buy in the market. Now, without it, I can't really sustain my business. Some sort of special equipment that only the other party can make. Money will not be a remedy because I can't buy it elsewhere. So in this case, the court may order that other person, that other company, to make that equipment as they can so that I can continue on my business. That's a specific performance. It's exceptional. It's not common. It's exceptional. Injunction, for instance. I'm supposed to have this singer in my club, and that has been a focal point of marketing. So because of this singer that I'm expecting a lot of customers coming in. Now, this singer not only breaches, but this singer says that she will sing at a club next door, right? It'll obviously be a disaster for my business. And in that case, money will not help. I cannot really recuperate from that. In that case, the court may order singer to be prevented from singing at another place. That's called injunction. So specific performance is the compulsion to do something. Injunction is prevention from doing something. The problem with that is it requires court supervision because somebody has to make sure that this breaching party performs or doesn't do something that's required, that's prohibited. So for specific performance or injunction, the court has to supervise, and that causes an issue with limited resources that developing countries have. There are other forms of remedy, including rescission, restitution, reformation. Again, I'm not going too deeply into that. These are the discretionary remedies offered by the courts. I'm just listing them for the sake of completeness. Now, remedies that are effective in the context of economic development are remedies that require low cost. So for the reasons I mentioned, money damages will be the low-cost remedy for the court. Order of specific performance may be granted, especially for those projects essential for economic development. So let's say that a company is under a contract to build bridges in a certain community A. The company can still do that, but for their business strategy, the company has decided not to perform the contract and pay for the damages. Well, the problem is it's difficult to find alternative builder for the bridge, and in this case, bridge may be very important for economic development of the region, and the court may very well order that company to build the bridge as they were planned because it's essential for economic development. So remedies of contract can be selected and strategically used by the state to promote economic development purpose. Okay, so let's go back to Malawan's question in the beginning that, look, if you look at, say, the development of China, property rights were limited, and there were limited private contract enforcement because you don't have a property in the first place, there's nothing to enforce. Yet, the China showed close to 10% economic growth every year since 1980. It's not until 2000s that the property rights and associated contracts were widely recognized by law. So you have to account for this 20 years plus time of growth, and this has to do with the mode of recognition. This has to do with a informal enforcement of contract. Mind that contracts do exist everywhere. Recognition by state, by law, is a different business. And for the purpose of economic transactions, enforcement is an issue, because people rarely look at contract law to figure out what they have to do, right? They look at contract, and as I said, contract does exist everywhere, whether or not recognized by state, and where the state's function is really essential is the enforcement issue. So your question, if I may restate, is how then did China develop the way it did without formal contract enforcement? And that has indeed been a subject of debate. Let's take a look at what formal enforcement means. That formal enforcement is enforcement by state following court proceedings. So enforcement by state entails a recognition of contract by state and enforcement by state, those two steps. It would be fair to say those two steps did not exist in many areas of transactions in China prior to 2007. Why? Well, because the private rights are limited. There is nothing to recognize. Because there is nothing to recognize, you cannot enforce it. Now, the classical position in this is that Douglas North, Nobel Prize winner in economics in the 90s, stated that the development of enforcement mechanism of contract is essential for economic development. So that doesn't help us because it says that enforcement mechanism of contract is essential, and at least we did not see formal enforcement for the reasons we have stated in the development cases. Also, formal enforcement, as we have seen in property context, requires institutional capacities and a mechanism, and that's a cost to the state. Again, back to our discussions. You have to have a well-functioning judiciary, you have to have efficient administration, and you have the compliance on the part of people too. Now, if you follow this conventional wisdom that we have to have a formal enforcement mechanism in place, it has a couple of issues here. One is that it'll create a cost for the society. And also, even if you are mildly successful in this, you have another danger of creating a culture that is judicious. So instead of talking to the other party on issues of contract, there might be a culture promoted with respect to the court access. You would go to the court for resolution. Yes, court function is important for enforcement, but in the economic development context, especially in the early stages where efficiency is an issue, creating excessively judicious culture is something that one has to think about. So now the UN promotes the rule of law as development agenda. And rule of law is not only functional for economic development. According to UN, it has to be an objective of development. At least in the early stages of economic development, this requires reconsideration because there might be a gap between economic development purpose and reality and the issues surrounding the rule of law, including raising judicious culture, which may not be economically efficient, and also all the costs to the state that need to be used for economic development itself. So straight back to your question back again, then how then was possible to see all the development without much of formal enforcement? But there is something else called an informal enforcement mechanism. So even without the court proceedings, state recognition enforcement, there's a substantial enforcement mechanism based upon business relations and reputation, personal honor, business interest, and community pressure. Where economic transactions are centering around close-knit community, at least in the early stages of economic development, among few innovative entrepreneurs who know each other, and in the small community setting, this informal mechanism tends to work. So, renowned scholars such as Trevor Koch have recognized that in the early stages of economic development, lack of formal enforcement is not barrier to economic development. So article mentioned in Guangdong Su's paper, Trevor Koch has mentioned that if you actually look at the empirical cases and try to solve this enigma as to why Chinese economic development was possible in the 80s and 90s without much of FPPR and a formal contract enforcement. This might be the reason that extensive informal enforcement mechanism in place. Now, there is a debate. Having said that, there is a debate whether this is sustainable. As Chinese economy expands and becomes complicated, then the parties that have to deal with business are strangers to each other, and the base of transaction is expensive enough that you can no longer rely on your personal reputation and interest and even culture. So there is an argument in favor of developing formal enforcement mechanism because of these changes. Okay? But at least in early stages of economic development, argument stands that you do not necessarily need formal contract enforcement, despite what the classical economists have said. So later stages of economic development have increased complexities in business transactions requiring formal enforcement.
Steve,
now, go ahead.
Sorry for interruption. I have a question here. That if informal enforcement mechanism is recommended in early stages of development, but in my country where informal enforcement mechanism is very strong, has led to certain kinds of problem. For example, it has led to a land grab that thousands of acres of land is grabbed or taken by people, and there is no informal enforcement mechanism, and that is tackling our economical growth. For example, you will see a 10-story building rising in a residential area, or you will have houses inside industrial areas. So how is it possible to tackle those problems?
Right, but let me clarify this. When you're saying land grabbing, there are a lot of land grabbing issues in Africa. Is it really a contract issue? Because how is that land grabbing happen? Somebody offers the land to a investor. Is that right?
Yes.
Right. So that transaction, offering a land to investor, is a contract, isn't it?
Yeah, it's a contract, but...
So what I'm trying to see here is the distinction between injustice associated with transaction and transaction itself. If that, whatever you call the land grabbing or land acquisition, has been done as a part of a recognizable contract, then it's not really a contract issue. It's more of a social justice issue. So the argument is, from investors' point of view, look, I have a contract to buy all this land. Of course, there is a question about whether the person who, or the body who turns over the land is really qualified to do this. I don't know about that. But let's assuming that land is legitimately given to that investor, then the point of enforcement is contrary. The point of enforcement would be, look, I have a right to this land because I have a contract over this land. Whatever issues there are not my problem. So in that case, I think you may be reversing the issue here, because what we're discussing here is a contract and contract enforcement. I'm not saying that, the possible social injustice associated with it. It's the same issue happening in China these days too, I've heard. In inner China, that, land belongs to state. So state agency, often cases as a result of corruption, signs a contract to turn over that land to a foreign investor, where all those residents in that land suffer from human injustice because they are displaced from the land where they traditionally cultivated, use for their benefit. But the law did not accommodate that. We talked about it in yesterday's lecture, the gap between the reality and the formal law. So in this case, at least the contract is concerned, the contract has been done because the contract is about transferring land. But issues of the people inside the land are not contract issue, are they?
Yes, yeah.
Yes.
Yep.
So it's another issue we have to talk about. But I hear you. These are important issues. I'm very concerned about them. But for the purpose of the lecture, I think we have distinguished the point of issue here. The issue, again, is a contract. And let me go on a little bit and get back to you as necessary, okay? So take a look at I hope I'm sharing the screen with you. Are you seeing the table 7.1?
Yes, I
Okay,
can.
good. And here, again, this is coming from World Bank, and they're trying to promote formal contract enforcement, obviously, and trying to show the world that the countries that are advancing economies have a shorter days of contract enforcement. So this table is about formal contract enforcement here. So if you look at the contract days, right? And if you look at the first column, many of these countries, I'm actually impressed that Russia only takes about 281 days to do the contract. I'm trying to see where China is, 406. So what World Bank is trying to say here seems to be that all the advanced countries tend to have a smaller days required for contract enforcement. And some of the poor countries like Bangladesh or India will have longer days. But if you look at this table more closely, the correlation is not that absolute. I mean, you have Greece, Israel, Italy, that are advanced economies with longer days of enforcement. You see that on the third column? Yeah, you'll be able to see that. And for me, the correlation is less clear. But the example here is to show you that many of the advanced countries seem to have lesser days for recognizing contracts. Then what? Do we or do we not go for the formal enforcement of contract? What it pertains to contract law, we have discussed three things today, right? Contract law, and enforcement. Now, contract is something that happens. I don't think you can control whether you will have a contract or not. Contract is a naturally occurring phenomenon in the sense that when people make a transaction, it happens. And it's separate from whether the state will recognize it by law. The second issue, whether the state recognizes, is the area of contract law. And again, the most of countries today, even very secluded economies such as North Korea, would like to have certain legal device, at least to attract foreign investments. So most jurisdictions today will have contract law, and elements of contract are not that dissimilar. So what we have laid out today are safely much of the common elements for the contract. So they are similar. The real issue here, vis-a-vis legal framework for business transactions and development, is enforcement area. Conventional wisdom is that you have to have a formal enforcement of court. But as we have seen in property area, the actual development cases do not seem to support that, at least in early stages of economic development. Not only in China, but if you look at Russia, if you look at South Korea, Taiwan, you wouldn't see much of formal enforcement. I'm not saying that there was no enforcement, there was. But the degree of importance attached to formal enforcement of contract seems to be unclear in the early stages. And advanced argument has been advanced for later stages, maybe it's more important. So the following is a suggested strategy for developing countries. There is a case for gradual adoption of formal enforcement benefit. Cost analysis is necessary. So as economies gets complex and transaction base expands, and when you're getting foreign investments, you would need formal enforcement. But you have to adapt it gradually in accordance with the local acceptance. And there has to be a flexible approach to make use of conventional informal enforcement mechanism. It's a better approach to use state power to focus on recurring problems in business transactions. So instead of copying down whole enforcement mechanism from some other country, it'll be wiser to focus on the real problem on the ground and try to link formal enforcement mechanism catering for those problems. In that, use of arbitration will be recommended because of its flexibility, expediency. So it'll make sense to use arbitrations tailored to transactions in question. More sensitive issues are linking criminal liability to contractual breach. As a fraud, for instance, it may be a contractual breach, but if misrepresentation is aggressive and it's excessive, then many jurisdictions will put a criminal penalty to it. Again, the determination has to be made by society to society. For foreign investments, however, even in the early stages, they would oftentimes require formal enforcement. So it'll be helpful to create services by state to provide the contract-related services on foreign investment. And it has been done in many countries. So separate from your own local situation, then the state will come up with a device to help with foreign investment vis-a-vis enforcement issues. And bilateral investment treaties will stipulate some of that, providing enforcement mechanism and options for investments. Now, we've mentioned that formal enforcement has a limited applicability and feasibility in early stages. But it doesn't mean that freedom of country is meaningless here. There is a case for licensing and governmental authorization, especially strategic natural resources, import and export transactions, and land transactions. And the licensing contract can be coordinated with economic development policies, again, particularly in the early stages. There's a control based upon public policy to correct unequal bargain powers between parties. We've laid out some examples, and again, the consideration is economic efficiency versus social justice. In early stages, one must mind about the lack of competition supply side. In early stages, that efficient entrepreneurs tend to be limited in numbers and they tend to dominate the market. So there is a need to address the unequal bargaining power by empowering state to intervene in a contract on behalf of weaker customers. So the control by state over, again, unequal relations seems to be justified. Should there be a general restrictions on the freedom of contract? It'll probably be unfeasible and unproductive in any stage of economic development, as seen in most secluded economies, such as North Korea. Even in that economic circumstances, the informal markets flourish and people have millions of transactions every day. So general restrictions on the freedom of contract may be unfeasible in any circumstances. Before making final points, I would mention briefly about the secure transactions, part because secure transactions are heavily promoted by international organizations, regional organizations, universities, and State Departments. So we need to cover a little bit about this and see the limitations and merits. Secure transaction is creating a security interest in personal property, not the real property in personal property. Why do we do that? To create a collateral for access to credit market. Advantage is obviously a single property can be used to support a series of loans, and debtor does not have to have the title to the property. So if you have a possessory right, then it can be used as collateral for a loan. A security interest may be created by contract. An important thing is that security interest created in a personal property would have to have a public notice so that the other people will know. So again, that's an issue of registration. And we do have the same problem here. Because creating a reliable registration requires a lot of expertise and then cost. So the benefit of creating registration will have to be checked against the possible cost. But the merit of registration is, obviously, registration creates priority by the time of filing. So the case for secure transaction is obviously by creating collateral, you create cheaper access to a credit market, and the cheaper credit is believed to be contributing to economic development. And much have to do with the effectiveness of the notice and cost of setting up registration system, which will be an issue in developing country. There is a possibility of conflict, as we have seen in real property. There's a conflict between the communal rights and the property and the security interest it created through a formal mechanism. Let's say that in a rural village with modest resource, there is a agriculture equipment commonly used, shared by everyone, and and theoretically, at least somebody could create a security interest in it, and there then could be a conflict between communal rights over that equipment and the security interest created in them. So legal facilitation of secure transactions must be done in a careful consideration of informal property rights. It's the same argument that we have made in the land registration issues. Balance between the customary rights and the formal rights, and attempt to eliminate customary rights, as have seen in Cambodia, will not work. And there is a bigger question here. Secure transactions could have a merit and a contribution, but essentially it goes for small-scale consumer loan. And the question is that how much of it is really effective for economic development by making small-scale loans more accessible by poor populations, and how much contribution can you really expect from that to economic development? And if you look at the East Asian cases of development, obviously, that development process was not based upon small-scale loan. It was based upon large-scale policy loans by government for target industries. So there's something that one must think about. Final points. Legal point framework for business transactions, such as contract, may contribute to economic development. So we're not denying the position made by classical economics and international agencies. Because it reduces transaction cost by clarifying and protecting rights and obligations of the parties to transactions. So it has a merit. The contents of contract law tend to have universal elements. That's the reason we have spent some time today to go over them. But the contents of contract law should also recognize prevalent local practice to increase applicability, effectiveness, and also local justice. You have to recognize the practice. Promotion of formal contract enforcement is conventional wisdom today to promote economic development. However, evidence does not necessarily support that it is essential for economic development. So we mentioned the case of China, academic research by Jabilcock and others show that it's not the case. Why is not the case? Because we have alternative informal mechanism based upon community relations, so forth. Is it sustainable on a permanent basis? Probably not, because business transactions become more complex, involving strangers, more expanded business bases, including foreign countries. So argument is that it may not be sustainable on a permanent basis, but it may be helpful, at least in the early stages. So what it means is that the informal contract enforcement should be recognized and utilized in the early stages. And a formal enforcement mechanism may become more necessary in the later stages. Okay, that concludes our lecture today. Again, I'll welcome your questions or comments.